Hello students, am I audible? Hello students, am I audible?
Yes, ma'am.
Yes, ma'am. Okay. Good afternoon to you students. Hello, sir.
I hope I'm audible to all of you.
Yes, sir. Yes, sir.
Yes. Okay.
Yeah. Yes, sir. Okay, good afternoon, everybody. Good afternoon, all the students. Today we have the third session for cybersecurity, module 2. We have with us Dr. Pratap Singh Sarunke, sir, with us. He has been associated with us since last 5 or 6 years. He has been delivering lectures for the students in the subject cybersecurity and cyber law. So welcome you to the college. I'm glad that you are here. I'm really pleased to have you once again for the students delivering the lecture. Students, sir is presently a faculty in Firodia, Navalbhai Firodia Law College, and he is expert in administrative and crime law. Sir, I welcome you to the lecture and I hand it over to you.
Okay. 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 Thank you. Thank you very much, ma'am.
Yeah.
I'm really thankful to Damle ma'am and entire team for inviting me and giving me the opportunity to interact with you on a very important topic under the cyber security and the specific segment which we are going to discuss in this session, that is introduction to intellectual property rights. It is very important to give due weightage to the intellectual property and the concept of intellectual property. Before we go into the niceties, I would like to give some live examples with the help of which we can understand and appreciate what is the significance of intellectual property in our day-to-day life and in real life situation. Few years back in Pune, one Ganesh Mandal that recreated a scene from a very celebrated and bestseller book written by J.K. Rowling, and that is, all of us are aware, is none other than Harry Potter. That Ganesh Mandal recreated a scene and that fetched crowd for that live scene, and because of that crowd and because of that captivating live scene, it appeared in the news items of Marathi, that is the local language in Maharashtra, as well as in English newspapers. Now, what happened? There was one law firm which was hired by the publisher of J.K. Rowling, that is of Harry Potter. That firm came to know that there is a scene from Harry Potter which is recreated in Pune, which is in Maharashtra, and that Ganesh Mandal has never asked for a written permission for recreation of that scene. Now, Ganesh Mandal was not having any idea about such concept known as a copyright. And that's why it never tried to get such permission either from the writer or from the publisher. And that's why that particular issue, which was erupted and that was blown up, and so the firm which was hired by J.K. Rowling, that law firm sent legal notice to the Ganesh Mandal in Pune, by stating that you have violated the Copyright Act, which is the Indian statute, which is an Indian law, and you have not paid any royalty, you have not paid any agreed amount to the either publisher or to the that particular author. Now, Ganesh Mandal was completely clueless about such kind of a concept. Later on, when that particular issue went in the court, then that Ganesh Mandal opted for the out-court settlement, and that issue was settled outside the court. But I'm very sure that none of the worker of that Ganesh Mandal would dare to watch the movie or any part of that particular movie of Harry Potter, having all these memories at the back of their mind. So this introduces us the significance and the need of intellectual property. And this is not the single example. There are other examples as well. Recently, you must have read in the newspaper about the controversy of Vishwas Patil with the director and the producer of movie Panipat. Panipat, as all of us are aware, is a very well-known novel in Marathi, which is written by Vishwas Patil, who is a very well-known author in Marathi and who has written Mahanayak, Panipat, Zada Zadti, and few other award-winning novels in Marathi. There are English translations which are also available of all these novels. Now, the director of movie Panipat and the producer of movie Panipat, they had their initial discussions with Vishwas Patil, because the director and producer were Maharashtrians. And that's why they had their initial meetings with Vishwas Patil. But later on, somehow, their financial calculations must not have been matched. And because of which, they never accepted the proposal of taking certain copyrights from Vishwas Patil for the novel of that particular Panipat. Later on, when that movie was released, in which Kriti Senan, Arjun Kapoor, and even Sanjay Dutt and important star cast which is there, when that movie was successful on the box office, at that time Vishwas Patil came before media and alleged that there was the initial deal to pay the royalty to me, and they have taken concept from me, and now they are retracting from their promise to pay that royalty to me. On the other hand, the director and the producer, they took a stand that we have never denied the fact that we discussed with Vishwas Patil. But somehow our financial equations, those were not matching. And that's why we dropped idea to take the copyright over that novel Panipat. But Vishwas Patil cannot claim any copyright over the incidents which has occurred, that is the Battle of Panipat. That is a fact, and which is not created by Vishwas Patil. So it is not the imaginary story which is written by Vishwas Patil. All the characters which are there, which are real historic figures. And it is not an artistic creation of Vishwas Patil. And that's why Vishwas Patil is not having any legal right over the Battle of Panipat. And we have made movie Panipat on the fact, on the phenomenon, on the historical fact, that is the Battle of Panipat. And that's why there is no question which arises to pay any royalty to Vishwas Patel, because we have not taken anything from his novel Panipat. And that's why there is no question of having any financial obligations on our shoulder. There is one more interesting incident, and few amongst you may have read in the news items about it, and that is the controversy between Rajkumar Hirani and Chetan Bhagat. Rajkumar Hirani's very successful movie Three Idiots, that is based on a novel 5 Point Someone, which is written by Chetan Bhagat. And if you see the titles, there is the credit which is also given to Chetan Bhagat for his novel. But later on, after that particular movie became a grand success, Chetan Bhagat came before media, and he was also vocal about it on the social networking site as well. He stated that when his mother watched movie Three Idiots, then she was very upset, because she was of opinion that the director, the screenplay writer, they have compromised on the storyline which is in the novel. However, on other hand, there was also the claim which was made by Chetan Bhagat that his name should not be there only in the credit for that particular novel on which that movie is based, but rather he should also be given the credit for the screenplay, credit for the dialogues, and few other things. But Rajkumar Hirani denied to do so by saying that we have given credit to Chetan Bhagat for that particular novel, and we have accepted and we have given due credit in our titles, that we have based our movie on 5 Point Someone, that novel, but that is not the end in itself. The skeleton we have taken from the novel, but there are many modifications, there are many scenes, there are many characters in the movie which are not there in that novel. And that's why there is an artistic liberty which is taken by us, and we have created. Rajkumar Hirani himself has written the dialogues and screenplay for the movie. Chetan Bhagat's claim was his name should appear along with that Rajkumar Hirani. But Rajkumar Hirani, as a director and as a story writer, as a dialogue writer, he was of opinion that it is his own creation. And that's why there is no question of giving credit to Chetan Bhagat for that particular thing. And the last example which I would like to give, and then we will actually start with this particular discussion on introduction to intellectual property right. And that is about the old movie Guide, The Guide. And that movie in which a very celebrated actor and well-known star Devanand acted, and he appears as a central figure in that particular movie. Now that movie is based on R.K. Narayan's novel titled with the same title, that is The Guide. In that movie and the controversy which was associated to it, this particular issue also came up for discussion, and that was the end of that movie that was different than that of the actual novel. So R.K. Narayan was upset with that particular end, and he complained with Vijay Anand, who was the elder brother of Devanand, who was a director of the movie and who was also the producer along with Devanand. So Devanand has acted in that movie, and Devanand has also produced along with his elder brother Vijay Anand for that particular movie. Now, R.K. Narayan, he was upset with the end because there was a change, and the stand which was taken by him, that there is a moral right which is with the author, and what the claim which was made by Devanand and Vijayanand as a producer, that we have paid royalty to R.K. Narayan and we have purchased that particular copyright over it. And now what we will do with it, that is our discretion. And you cannot interfere with it. That was a very important stand which was taken by them. And in that situation, it was considered that definitely the royalty is received by the author, but that doesn't mean that author is not having any right as far as his own creation is concerned. So definitely author must retain some right, and that is known as a moral right over that particular creation. So these are few incidents which are stray incidents, but which are pointing out towards one very important fact, and that is the significance of intellectual property and its protection in contemporary situation. Now, having said this, now when we look at intellectual property and the right which is associated with it, then we have to understand that there is a quest in the mind of a human being, and that quest is for creation of wealth. And human beings, they have retained this quest right from the initial phase of our evolution. And this quest for creation of a wealth, and wealth is in a different forms, tangible and intangible one, but that quest is always there. And the tools for the creation of the wealth, those tools are also changing. Because when humans evolved from hunter-gatherers to the agriculturists, then land became an important embodiment to symbolize wealth. Earlier, when man was wandering in the forests, and when we are talking about the phase prior to the agricultural culture, then at that time, land was not symbolizing the wealth. But later on, man settled down, and this particular land, which became the important commodity. And this particular land, which helped to create that particular wealth. With passage of time, this incidence also changed. This phenomenon also underwent a sea change, and then technology, which has become the most important tool for the creation of wealth. And this creation of a wealth with the help of technology, that became the buzzword, that became the new currency. Intellectual property and rights which are associated with the intellectual property, which provided a legal fencing to the tool of wealth creation. Now, if you are owner of a copyright, for example, if you have written a book and someone wants to make movie on it, then definitely that person will pay you a hefty amount for royalty for giving the copyright to that person for making that movie. Or if you have invented a particular part or a particular object for which you have opted for a patent, and that patent right which is with you, then certainly it will helpful to you to get that royalty or the license fee from such particular person. Or if you have registered for a geographical indication, like in Pune, Puneri Pagdi, which is there and which is registered as a geographical indication, or even Bakarwadi of Chitales, that is also registered as that particular geographical indication, or even the oranges of Nagpur, those are also registered as the geographical indications, or even the grapes of Nashik, those are Tasgaon, that particular variety is registered as the geographical indication, or Paithani from Paithan, or even the Kanjivaram sari, that is also registered as someone has unmuted. So I will request to mute themselves so that it will not create disturbance for the others.
आता हे सगळं सुरू झालं तर तुझं पण सुरू होईल का काय?
Okay. So
Students, see that please you mute yourself. Do not unmute yourself. See that there is no disturbance in the lecture. I request all of you to mute yourself. Thank you. Sorry, sir.
Okay. No issue. The thing is, this particular technology which helps you to multiply the force and which allows you to create that particular wealth. And that's why in contemporary era, intellectual property right, which is the important tool for this wealth creation. A simple example how this intellectual property, it is significant one. If you are having a 15-acre land, then you can fence it. But if your market is regional, if your market is national, if your market is global, and you are manufacturing a marketable article which you sell out globally, then where you will put that fence? This is a very basic question which needs to be answered. And that is provided, this particular difficulty which is resolved by intellectual property right. Because earlier that was a phenomenon that if you have invented any product and which is having a patent in its name, then you were required to go to each and every country for protection of that particular right associated with the product. Then products are of two types, product patent and the process patent. We are going to discuss that part when we will discuss the patent. But now when the market is global, then we need to understand the protection which is made available, that is the global protection. And now after the TRIPS agreement, trade related aspect, and the agreement which is entered, the role of a WTO in this particular regard, that we are witnessing in day-to-day situation. Now, you must have read in the news item that India and Africa, they have lobbied with WTO for waiver of intellectual property for the vaccine of COVID-19. India, along with South Africa, has taken a stand that there should be no intellectual property right which should be associated with the vaccine of COVID-19. Now, when you provide any such protection, then you need to take into account.
आणि कुठेही तू गेलं तरी आधी ट्रेनिंग शिवाय काहीही नोकरी नाही.
Kindly unmute yourself. Mute yourself.
Wow.
Sai, please mute yourself.
Ma'am, you can do one thing. You
Yeah.
can mute all, and then you can give permission to only few, so that they can unmute themselves. So that will be better, I think. Okay, okay. She has muted, so there is no issue. Okay, we will continue. So the comprehensive approach, if we take into account in relation with the protection of the intellectual property, that if you invent a pen, then you register for a patent for the technology by which that pen is manufactured or it is created. The design of that particular pen, if it is unique, if it is non-obvious, which is novel, which is original, then you will go for industrial design for shape of that particular pen. When you go in the market to advertise your product, then the brand which you have established, it is the trademark which gives you protection for that particular purpose. The copyright, which is also there for accompanying literature, which is there for the marketing purpose of that pen, so which also takes in its fold that copyright. So in just one example, you can position comprehensive approach and cover your invention by many intellectual property rights and different legislations which are providing protection to your creation. The comprehensive approach as far as the intellectual property is concerned, if you take into account, then you find there is a design which is for the appearance. There is a patent for the technology. Patent is of two types, product patent and process patent. Copyright, it is for the accompanying literature, and the trademark, it is for the brand. So this intellectual property which helps you to safeguard your interest. Now, if you have a cursory glance over the history of intellectual property right regime, then you find the Greek states were the first to grant the patents for the inventions during the 15th century. So you can understand that how the European and Western countries were very much commercially aware and alert about the intellectual property rights. But until the Industrial Revolution, intellectual property right did not acquire any commercial or legal significance. So the commercial or legal significance to the intellectual property right, it started gaining from the 19th century onward. It doesn't mean that intellectual property as a concept was not there prior to 19th century, but it was in a very raw form. It was not in a very articulated, finished form that we can understand in this particular regard. In 1604, Statute of Monopolies, which is a British statute, or which is the English law, it tried to restrict the powers of the crown to grant monopolies than a genuine desire to protect literary, artistic, sculptural, or technological work. And this 1604 statute, which is protecting the monopolies in British legal system, is a pivotal and a significant statute to safeguard the rights which are associated with that particular product. The international history of intellectual property, if you take into account, then 1861, where the Berne Convention was there as far as the intellectual property and the protection in that particular regard. And so the Berne Convention is very significant for the protection of copyright. And this was a very significant and important development. In 1882, Paris Convention was there for the protection of the industrial property. And industrial property, which is having a high stake as far as that particular commercial stakes which are involved. And for that matter, this Paris Convention, it has played a very significant role as far as the industrial property is concerned. Then there is a BIRPI, BIRPI. This is an acronym, a private organization for the protection of the intellectual property rights and global protection. It should be given. This was the appeal which was made by this private organization at the international plane. And then in 1957, there is a birth of WIPO, World Intellectual Property Organization. The acronym is WIPO, which became the repository organization for all the international treaties for protection of the intellectual property. In 1994, WIPO became a specialized agency of the United Nations and which acted as a very important force for protection of the commercial rights at the national level as well as international level. And this aspect which we need to take into account in that particular regard, that this is the protection which is needed at the national level and the same protection which is also required at the international level for protection of the intellectual property. When we come to Indian case, then we find that Indian legal regime for the intellectual property right, it is also based on the international developments. So there are many legislations in India which are enacted because the international law, international treaty or international development which has demanded the state authorities to make law to that particular effect. So how that particular journey which can be traced, if we take into account, then we find that the first trace which we can definitely underline, it is the Indian Patent and Designs Act of 1911. Now this Patent and Designs Act, which is a pre-independent statute, which played a significant role for protection of the intellectual property in Indian colony. Now this law, which is based on a UK law, and as India was a colony of Britain, so British administrators, they adopted a policy to introduce in their colony the laws which were identical to their national law, so that it will be convenient for them to administer in such situation, and which is quite natural as well, because these administrators were accustomed with their own legal system. They were well aware about the laws in their legal system, and that's why they were inclined to take those laws in the municipal legal system or at the national level legal system in their respective colonies. Though there may be slight changes into it, but its skeleton, its overview, if you take into account, then that is the same one. The Patent Act of 1970, which came into force on April 1972. And this Patent Act, which has also played a very significant role as far as the protection of intellectual property in the marketable article, as well as the process which is adopted to manufacture that marketable article is concerned. There are certain amendments which are also introduced to keep pace with the changing circumstances. And the Patent Amendment Act of 1999, which came into force from 1st January 1995, and it has played a very significant role in bringing and in introducing the new changes which are required by the market. It is very well said that law is like a walking stick. It should always remain one step ahead. So law should never turn a blind eye to the changing circumstances. Law should always take in its fold the changing situation, and then only it will keep the pace with the changing circumstances. When law will stop responding to the existing situation, then that law will become meaningless. That law will lose its significance. World Trade Organization and the United Nations is also a very important organization which is at the international plane. WTO will prove to be a more effective international organization because of its compulsory dispute settlement power. When two or more countries, when they will enter into any contractual relationship or any commercial relationship, then definitely there will be a disagreement. There will be a dispute. There is a chance that there will be a dispute. So how to resolve that dispute, that is the important question. And this particular dispute is required to be settled by having amicable settlement, and WTO has justified its role in settling that particular dispute in amicable and in a very practicable way. Under WTO, absence of adequate IPR protection is a type of subsidy to the domestic business which all the nations, including the India, have undertaken to phase out. And that's why this role of a WTO, which is really a very significant in that particular regard. So, Indian legal regime, if you take into account in this particular regard, is really very important. And the Patent Amendment Act of 2002, which came into force from 20th May 2003. And this particular patent amendment has introduced many important amendments in that particular regard, and which has definitely played a very significant role in introducing technologically important changes into the legal mechanism. The Patent Amendment Act of 2005, which came into force in January 2005, which is also the example to introduce new technological advancements into the legal regime. The Copyright Act of 1956, which came into effect from January 1958, which has played a significant role in that particular regard. Just give me one moment. So, this international development, it has always played a very significant role to introduce necessary changes at the national level. And definitely, especially if you take into account the current vaccine thing, then India, which has lobbied for waiver of the intellectual property right, that is specifically if we refer, it is a patent law. But there is a difficulty, and I will tell you that when India and few African countries, they have claimed that this is a global pandemic, and to combat with it, we should waive the intellectual property right over the vaccine, and then vaccine can be manufactured by majority of the pharmaceutical companies in their respective countries, and that's how we can save the humanity. It appears as very attractive claim. It appears as a very popular claim as well. But what is the reality? The reality is, if you just take a glance, the initial investment for the Serum Institute, which is a premier institute to manufacture vaccines in India, the primary basic rudimentary investment which was required for the setup of Covishield vaccine, that was of 3,000 crore. I repeat, 3,000 crore. Now, when such a figure is involved, and later on you are claiming that we will not pay you any royalty, we will not pay you any compensation, and you have to give it to us free of cost, then can you imagine that in future any company will invest heavily for research and development wing of any such vaccine? And mind well, the clinical trial, vaccine, immunization, these are very costly affairs, and for which heavy investment which is required. And the culture of a research and development which can stand on its own footing only if the financial support which is available without any hindrance. And that's why you will find that the other companies, may it be Moderna, may it be AstraZeneca, may it be Pfizer, all these companies, though they appear as a private companies, but under their national public health policies, they have received enormous public fund, that is the government grants, for manufacturation or for carrying out the research and development of the vaccines. And when we say that vaccine should be available to all of us free of cost, then definitely you are compromising the quality of that particular research and development. One thing which you need to understand, that the vaccine is manufactured by a pharmaceutical company, and pharmaceutical company is different than the charitable trust. Charitable trust may do certain things for charity, for philanthropy. A company is there to make a profit. It may appear very harsh, it may appear very, in a way, arrogant, but it is true, because later on it will not be possible for any company to go for such research and development in that particular regard. And that's why instead of going for popular announcements like waiver of the intellectual property, you should go for the other ways and mechanisms by which you can safeguard the financial interest of the manufacturer as well as the interest of the weaker section in the society. I am completely in for the policy that those who are below poverty line, for them, the vaccination cost that should be shouldered by the central or the state government. But all the citizens, those who can pay, even they should get it for free of cost. And for this popular kind of a announcement, you will not pay to the companies when companies have invested in multi-crore for the project of that vaccination, then it will not meet the end. It will create systemic problems. And this aspect which also we need to take into account in this particular regard. So this is a very essential aspect which we have to be very cautious when we are dealing with any intellectual property and any demand which is associated with the protection or the waiver of the intellectual property. The Trade and Mercantiles Act of 1957, which came into force on 25th November 1959, which is now repealed, is also one important kind of a legislation in this regard, which definitely helped for protection of the commercial interest of the trader who has registered that word mark or the trademark, and because of which you can easily make out that who is the manufacturer of that marketable article. The trademark or that particular device mark, which is a very important sign or the symbol which is available, and because of which you can definitely make out the make of that product. It can be any natural or any artificial symbol. For example, the eaten apple, which is used by Apple on all their iPhones and all other laptop and other electronic gadgets or the product. Now, Apple is a natural product, agricultural product, but a special shape which is created, that is a bite which is taken from that particular apple, which makes it unique, and that helps to understand that this laptop or this particular iPhone is of Apple company. So who is the maker or the manufacturer of that particular product? That is a very important consideration, and that needs to be very clear. because someone else should not sell his or her product as the product of someone else just to take disadvantage of the goodwill of that particular trader in the market. And this is a very important protection and very important legislative policy in this particular regard. Then there is the Designs Act of 2000, which came into force on 1st May 2001. It is the enactment, or it is the statute which is important for the shape, for the color, for the line combination or the color combination. All these things which help the customer to take the decision. When any person of ordinary prudence goes for purchasing any marketable article, then on what basis that person is going to take a decision? If you go in any restaurant or if you go to any shop where cold drinks are available, and if you look at a Coca-Cola bottle, then the shape of a Coca-Cola bottle is unique. It is slightly different than other such beverages or other such soft drinks. Why? Because it is the industrial design and which is registered by Coca-Cola, so that persons can easily make out that who is the maker of that particular soft drink. And there is a brand value that you need to take into account. And we go for that credibility for the brand, and accordingly we take our decision. For example, if you go to any particular ready-made clothing shops, and when you ask for Van Heusen or Zodiac, or when you ask for Peter England, these are the brands and for which you are ready to pay the higher price, because all other rival brands, they are available to you even at a 50% less price. But still, few amongst you who are brand conscious will go for that product. Why we few amongst us go only for Apple iPhone or the laptop? It is because of the credibility which is associated with it. And that's why this intellectual property and the protection which is associated to it is really very significant for that particular purpose. Next legislation is the Protection of the Plant Varieties and the Farmers' Right Act of 2001. Now, this came into force in October 2006. The plant varieties, now farmers are having the traditional knowledge, and the plant varieties are protected by resorting to their traditional knowledge. And these plant varieties and the farmer's right, which is definitely providing the protection to the traditional knowledge of the farmers or the persons who are associated with the agricultural business, and for protection of their traditional knowledge, this right of 2000, Act of 2001, which is enacted, and this is how this right which is safeguarded. The Semiconductor Integrated Circuit Layout Design Act of 2000, this is the act which came into force in 2003, which is also important for the integrated circuit semiconductor layout and designs. Especially if we open our laptop, if we open our mobile phone, if we open any electronic gadget, then there are semiconductors, there are integrated circuits, there are layouts and design. That's how that particular electronic gadget that works. And that combination, how it is required to be protected, and for that purpose, this Act of 2001, that is really a very significant in that particular regard. The next point, that is the infringement of intellectual property right. So what constitutes infringement and how that is dealt by the legal system is our next point for our consideration. For a trademark, copyright and design infringement, there can be civil as well as criminal liability. For patent, semiconductor chips, plant variety and its infringement, there can be only civil remedy. All the IPR infringement cases, it can be initiated before the district court, and accordingly that matter that will be heard. Even when movie Sairat in Marathi, when it became a blockbuster hit, at that time, after its release and when it was running successfully, then there was a case which was instituted in Pune District and Sessions Court by stating that the director, story writer, dialogue writer, screenplay writer, Nagaraj Manjule, has copied that work from one novel, and that plot is taken from that particular novel. But court decided that particular case in favor of Z Telefilm, which is the producer of that particular movie Sairat, and the relief was given to director and writer Nagaraj Manjule by saying that there is no claim, or it doesn't hold any water as far as these accusations which are made by that particular fellow in that case is concerned. There is a facility of an interim relief as well. Normally, an interim relief, it is granted if the following conditions are fulfilled. First, existence of a prima facie case in intellectual property matters. Prima facie case has to be considered in the light of possible defenses available to the defendant, and accordingly this particular prima facie case, whether it is made out in favor of the petitioner or in favor of a defendant, that can be considered. And balance of convenience, it is a technical term which is associated with a very important part, that it has to be considered in the light of the doctrine of irreparable harm and the relative hardship. For example, the interim relief, you are claiming that you are the owner of the IPR and another person is saying he or she is the owner of intellectual property in that particular situation. So the interim relief is the intermediate relief which is given till the finally that particular case is disposed of by the court. For example, now movie is running in the theater and someone has filed a case in the High Court or the Supreme Court by saying that I am the original writer of it. Now, what could be the interim relief? Interim relief is to give the stay to that particular public screening of the movie. So in that case, the balance of convenience, which is taken into account, that who will suffer greater hardship. And when that loss which is caused, if it is irreparable loss, which cannot be even remedied by paying compensation, which is a monetary kind of a relief which is given, then in such situation, the actual relief which is given, that is the stay order and allied orders which are passed in that particular regard. Now, there are some contemporary issues in relation with the intellectual property rights which are associated. Out of which the first issue, it is the development of biotechnology and gene mapping. Now, few amongst you who may be the students of life sciences, they may be aware that right now, very serious research which is ongoing in the genetic engineering. And now this research is ongoing, and if this particular research is successful, then you will be permitted, or you will be in a position to interfere or to modify with the genes as well. What will be its effect in a layman's language? If we want to understand it, then in that situation, if a particular lady is pregnant, then because of this gene mapping, that baby which is in the mother's womb, what should be the skin color of that baby? What should be the texture of the hair of that baby? What should be the color of eyes of that baby? What should be the physique of that baby? That can be determined, and there are many other factors. Now, this is known as a designer baby. Like you design a suit, you are permitted to design a baby. Should it be permitted or not? Because it is going to be the interference in the order of a nature. And if it is permitted, then it will lead to some perennial problems as well. For example, right now, there is a very thorough research which is ongoing and which is at a very serious mode. And that gives us understanding that in this genetic engineering, attempt is made to modify the genes, to modify DNA in such a manner, to tamper DNA in such a manner that person will not suffer from serious illnesses like cancer, like other such life-threatening diseases. Now, if it is permitted to greater extent, and if the gene is modified to such an extent where the aging of a person that can be ceased, or person will not suffer from any bodily ailment even after attaining the old age, then there is a possibility that person may not die. And if you achieve that immortality, and research is ongoing in that regard as well, if every person who has taken birth in this world, if that person is not going to die, can you imagine what will be the situation? Now the cycle of a nature is so that when we die, we make available a space to other generation. So after our lifespan is over, we should depart from this world. This is the current structure. But this research has seriously challenged this life cycle of nature. There are many other legal, ethical issues which are also involved in it. The second contemporary issue, that is about the legal protection of the computer softwares. There are many softwares which we are using on day-to-day basis. And because of pandemic, now the use of the computer, use of a laptop, use of a tablet, it has become very, very common. And that's why the scale which has changed to magnificent level. And that's why the use of these softwares, the privacy issues, and many such aspects which are involved. Recently, you must be reading the issues as far as privacy is concerned, that is associated with WhatsApp, that is associated with Facebook, that is associated with Twitter, that is associated with Gmail, Yahoo, Hotmail, and the tracking which is there. For example, if you search on the internet, your email ID is tagged with it. So later on, automatically, you find that from next day onward, there are advertisements which are pouring in your inbox. Who gave them this information that you search for such and such product? So the privacy issues and many other such allied issues which are also there. And then the third issue, which is equally significant one and important one, and that is public health versus profit concerns. Few years back, there was a case that was Novartis. What happened? Novartis is a multinational company. It is a pharmaceutical company which manufactured a drug in relation with a life-threatening disease like cancer. Now, Section 2D of the Patent Act, which requires that any invention which is new, which is original, only that will get registration for a patent. And if there are only cosmetic changes, like you have changed the color, you have changed the shape of the bottle, all these things will not constitute originality of that particular product or the process. In Europe, rules as far as granting patents are quite relaxed one. Even if these minor changes are carried out, still you will get patent for that new product. However, in India, this minor modification will not entitle you to get new patent for the product. For example, you have changed only the color of a syrup. If earlier syrup color was red and now it is black, there is no significant change in the effectiveness of that syrup. Until the time there is no significant change as far as its effectiveness is concerned, why that patent should be granted? That is a very simple and logical question which is asked by the Indian legal system. But same is not there in the European countries. And even the minor change will allow you to give patent to the minor or some cosmetic changed processes. This is known as evergreening of patent. So whether this evergreening of patent should be permitted. Why? Because if you give patent to a particular company, then a monopoly is created in favor of that company. And if anyone else want to manufacture that medicine, then you have to take license from that original company which has manufactured it. It is quite logical. But because of that monopoly, company will charge a very hefty license fee for the same. So in that regard, that particular life-saving drug, if it is available at a very expensive price, is it justified? Initially, we discussed the waiver of a IPR as far as vaccine is concerned. There we criticize this particular issue. But here, the another extreme end which we are discussing, where any such product where in that situation profiteering to such an offensive extent whether should be permitted. And in India, answer is quite simple. In India, right to life is associated with right to medical help. And that's why there is a control of a government as far as life-saving drugs are concerned, its manufacturation is concerned, its distribution is concerned. And that's why you must have read in the news items for remdesivir injections, which is now not allowed to be used for COVID-19 patient. But there was a time in April and May 2021 when the relatives of the COVID-19 infected patients, they were running from one pharmaceutical store to another pharmaceutical store, from one collector to another collector to get the vials of that remdesivir. Because at that point of time, it was a life-saving drug. And that's why there was a black marketing. And for that purpose, the collectors were given the powers for a distribution of that life-saving drug. So this is the legislative policy which we need to take into account as far as protection of the intellectual property rights are concerned. Now, one by one, when we look at the copyright, then it protects the literary and artistic work, movies, drama, songs, lyric, musical composition, books, films, computer softwares. All these things are covered under copyright. Creation of a knowledge which is primarily protected by the copyright system, because you have taken the intellectual labor, like you hire a labor. For example, you have hired a carpenter, plumber, and you have not paid him or her. Will it be possible? It will not be legal. In the same manner, the intellectual labor which is taken by someone, it should not be utilized by somebody else without the proper authority. So the requirements are two. One is originality and second is reduction into a tangible form. If these two conditions are fulfilled, copyright which can be granted in that situation. There are different kinds of right under the copyright. The right vary according to the class of the work in that particular copyright. In the case of a literary work, except for the computer program, the dramatic work, artistic work, musical work, copyright means the exclusive right. It means the monopoly right. So what are the different rights which are associated to copyright? The right is to reproduce the work, to issue copies of the work to the public, to perform that work in the public, to communicate the work to the public, to make the cinematography film or sound recording in respect of that work, to make any translation of the work, or to make any adaptation of the work. For example, Chetan Bhagat's novel is taken as a base and on which movie is made. It is known as adaptation. If any drama is there, for example, Natasamrat, on which a movie was made by Mahesh Manjrekar in which Nana Patekar has acted, that is known as an adaptation of that work. The cinematography film, where the copyright means the exclusive right to make a copy of a film, including the photograph of any image forming that particular part itself. to sell, to give, to hire, offer for sale, all these rights, those are made available. To communicate the cinematography film to the public, this right is also made available. In the case of the sound recording, copyright means the exclusive right. And to make any sound recording, which is embodying it, to sell, to give for a hire, or the copy of that particular sound recording, all these things are protected under the Copyright Act, and the original creator is safeguarded because the royalty will be paid to that particular original creator. The performer's right is also the part and parcel of that particular copyright. A performer has the right in relation with his performance. One is right to make a sound recording, visual recording of that particular performance, right to reproduce the sound recording or the visual recording of the performance, right to broadcast the performance, right to communicate the performance to the public otherwise than that of the broadcast. These are known as the performer's right. So a performer who is communicating it to the public at large. So that performer is having these rights besides that particular creator. The duration of a copyright, if you take into account the literary, dramatic, musical, or artistic work other than the photograph, the term of protection which is extended is 60 years from the beginning of the calendar year next following the year in which that author dies. For example, if the author who dies in 2021, so the next calendar year, that is 2022, and 60 years from that calendar year, so 2082 is the year till which that copyright which will be protected. And legal heirs of that author or the legal representatives of that author, they will get benefit of that royalty, benefit of that particular monetary gain in that regard. Photograph, it is having a protection of 50 years from the next calendar year after the cinematographic work and this particular work which is safeguarded. So the lifespan is the 50 years from the next calendar year. The sound recording will have a protection for 60 years from the beginning of the calendar year when it is published. A performer's right which subsists for 25 years. There was a controversy, if you have read in the news items, there was a controversy between Yesudas and Ilaiyaraaja. Both are very well-known and towering personality, especially in South film industry and also in Bollywood film industry, especially movie Sadma, in which Yesudas has sung the song and for which the music which is given by Ilaiyaraaja. And Ilaiyaraaja has given music to many successful movies in the South and also in the Bollywood. So in 80s and 90s, that was the era of Ilaiyaraaja. When every successful movie, majority of the movies for which the music direction that was given by Ilaiyaraaja. Now, there was a controversy where Yesudas claimed that as a performer in a live performance, Those songs are popular because I'm singing it. And the Eli Raja, who was a music composer director, he was claiming that I am setting up this particular compositions. I am giving the directions to the various instruments and musicians. And that's why it is my design. So I am responsible for its success. Now, this controversy is still there, but it has underlined one very important point, and it is that particular part, that is, performer is also having certain rights, and second, that is, the creator is also having right in that particular regard. The term of a protection as a broadcaster, that particular term is for 25 years. For example, Color Channel has purchased that particular copyright. So that broadcaster's right is with Color Channel or HBO Channel or Star Movie Channel or Z Talkies Channel. It is for 25 years. The authorities under the Copyright Act, the registration of that particular copyright and the registrar of the copyright, which is with New Delhi, is the important authority in this particular regard. The next IPR is the patent. The application of a created knowledge to produce useful result. This is primarily protected by the patent system. The requirements are novelty and originality, or the utility. The utility means the invention is capable of industrial application, and all the inventions that have commercial applications except that are excluded from the patentability. The duration which is provided is for 20 years from the date of application, and the registration for the patent, it is necessary. However, for a copyright, it is not necessary. The moment at which you publish it, whether you formally complete the procedure for registration for the copyright or not, if you have written a book, whether you have actually taken a copyright or not, it is immaterial. If you are original author of it, if you have not plagiarized from anyone else's work, and it is not obscene, scandalous, then you are entitled for the copyright. But patent is different than this. For patent, registration is compulsory. The rationale behind the patent protection is there is a disclosure theory. This enables the inventor to disclose his invention to the public instead of keeping it as a trade secret. And it's commercial exploitation which definitely boosts the market and that accelerates the economic process as well. After the expiry of the monopoly period, any interested person can use the specification for replacing the invention, and for which this plays a very significant role. The rationale behind the patent protection. The incentive theory, which states that patents add fuel to the fire of genius, which is pointed out by Abe Lincoln, where the creation of a technology is highly capital and risk intensive. So the patent monopoly that is required to be safeguarded and rewarded. Every invention improves the quality of life, and patent provides a chance to make the commercial success of that particular invention. The office of the patent, it is in Mumbai, it is in Kolkata, it is in New Delhi, it is in Chennai. The next intellectual property right, it is trademark. So for marks that are applied to the goods in the trade, it is intended to convey the purchaser the origin of the goods and the assurance that goods bearing the mark are of same quality. Why you go for the electronic items of Sony, Bose, Bolt, or such reputed companies? It is because you are having the assurance about its performance, assurance about its quality. What is going to be the duration of the trademark, like copyright or patent? Here, trademark is different than all other intellectual property rights, where the duration for the trademark is infinity. But the registration, that is optional, and it is not compulsory that when you go for the registration, then only protection which will be made available to you. The trademark, which is considered as the mother of advertising industry, because the public interest and the concern which is taken care by the Trademark Act. It helps the consumer to choose the product. A commercial certificate on the origin of the good, that is in the form of the trademark. It prevents unjust enrichment and misappropriation of a commercial goodwill by some unauthorized person. It serves as a representation to consumer that the goods bearing the same mark conform to the particular standard of a quality. The trademark infringement, when it is not registered, it is in the form of a passing off, for which a civil action which can be taken. Even the unregistered mark can have the protection under the law of common law, that is the passing off. Mere the possibility of confusion, that is enough to grant the relief in that regard. And registration is a prima facie proof of ownership of that trademark. And later on, if you are having any contrary material with you, which can challenge that particular registration of a trademark, that is also permitted. The actual deception, which should be proved by the party which is alleging to that effect. And the plaintiff has to prove that the continuous use has acquired the ownership of the mark in question. The trademark infringement is considered as actionable per se, and registered trademark owner can sue at the place of the business. The next intellectual property right is industrial design. There are certain essential features which we need to take into account in this regard. And it is appeal to an eye, novelty and originality, publication, registration of design, rights conferred by registration, infringement, and defenses. These are the points which we need to take into account when industrial design, which is there. The passing of action, which is a damage to the plaintiff, and that can be definitely claimed or initiated when the action arose in that particular business. The next intellectual property right, it is geographical indication. The protection is available for the goods that have the specific geographical origin and possesses the quality or the reputation due to the place of origin. We are ready to pay more money for apples from Kashmir. We are ready to pay more for that particular grapes from Nashik or Tasgaon. We are ready to pay more for oranges from Nagpur. We are ready to pay more for the Kanjivaram silk or for Paithani. Why it is so? It is because the geographical origin which assures that particular quality. So this is an intellectual property right which is held as very, very important one. So geographical indication is not granted to individual, but it is granted to a group of people. For example, Kolhapuri chappal is a glaring example of a geographical indication. That particular chappal is not available only to a particular shop owner, but it is available to all the shop owners which are manufacturing that particular chappal by observing the quality standard which is known as a Kolhapuri chappal. So there must be a specific link between the products and the original place of protection, which is very important in that regard. The geographical indication, it can be perpetual. The geographical indication and the Goods Protection Act of 1999, where the filing of the application which is there and registration which will be granted accordingly. The process of the application which will be monitored by registrar for geographical indication, and there will be the application which will be advertised in the newspaper under section 13. The process of filing an application where the opposition to that application which is available under section 14 within the 3 months. If you want to oppose that why that geographical indication should not get that protection or the registration, then this is possible under section 14 within 3 months. The correction and the amendment in that geographical indication, which will be under section 10, no opposition of application. If it is there, then registration which will be granted under section 12 in that regard. Now, what are the application content? That is very essential to understand. The name, the address of the applicant, so that you can identify that particular person, for which it is really very essential. Name of the geographical indication, which is adopted, logo if there is any, so that you can represent that particular logo of the geographical indication. You have to mention the class of goods, because there are various classes for which that geographical indication which is granted. So you have to specify that class of goods. Then the documentary evidence which in support of the legal status of that applicant, such as memorandum and article of association, bylaw, registration, certificates, that can be attached along with that particular application. The statement containing the list of the members or the producers of that particular goods who are requesting for such kind of a protection, that can also be conferred and which will be supplied. Certificate in case of a convention application. If there is a convention, then the certificate to that effect which can be produced. Description of goods and the specification, that can also be provided. The proof of origin, that it originated in that area, in that geographical territory, that will be mentioned in it. The geographical area which justifies its existence, that can also be taken into account. The geographical indications and its registry is in Chennai, and accordingly that registration process which can be taken into account. And the concluding part, and with this we will open the floor for the questions, that is the plant varieties and registration for the same. A new variety of the existing species, if it discloses a new characteristics which is beneficial, the same can be protected under the plant variety and act to that effect. This particular protection, which is available for the quality and maintaining the standard, it must have novelty, it must have a distinctiveness, it must have uniformity, and it must have stability. For example, now Devgad Hapus or that particular Ratnagiri Hapus is a special variety of mangoes, and that is having a uniqueness, that is having a distinct feature, and that is uniform for years together. There is a continuity of that particular test. So this plant variety, which is registrable one, or even the Kesher or even the Sindhu for that particular matter, these are also the varieties of mangoes in this particular regard. The Indian law, which protects the rights of the farmers to use the seeds of the new variety without any restriction from the registered owner. And this is a very important kind of protection which is made available. And the period of protection, which depends on the type of that particular plant. So this is all about the introduction to the intellectual property rights in a nutshell. So if you have any query, you can ask, and then we will conclude this particular session. Thank you.
Hello, sir. Am I audible?
Yes, ma'am. Yes, you are audible. Yes, ma'am. If there is any query, we can take query. If not, then we can conclude the session. Okay. So who falls under the category of artists and performer? Now, artists and performer, that particular line is very blurred. But one thing for law, it is very clear. For example, the creator of that creation, for example, a movie which is based on a novel, that novel is written by the author. That author is artist for the purpose of Copyright Act because he has created it. And the performer, for example, if there is a movie which is made on that particular novel and some actor or actress has acted in that movie, they are performer. So creator is someone who has created. It is his or her idea which is germinated and which is commercially applied. And others, they have just rendered their services and they have acted in pieces. Like lyricists, they have done their job. Actors or actresses, they have done their job. Fight masters, they have done their job. Choreographer, they have done their job. So all these are the performers. Performance may be visible performers or behind curtain performers. But these performers, they come together to have an effect. So artist is a person who has originally created it, like the author, and the performers who may have rendered their services and they have accepted a particular fee for the same, but that idea is not their own. That is associated with the performer. So any actor or actresses who may be acting in a movie, though that particular acting itself is also creation, but for law, the author of that particular movie or writer of that particular movie is the artist and others are the performers. So it is from legal sense. Actually, all are artists in that sense. But for legal sense, who has originated that idea, or when that idea flows from a particular person, then that person is considered as artist. Okay. Is there any further query?
Is there any query further? Since there is no further query,
Okay.
sir, I would really like to thank you for coming for the lecture. From your busy schedule, you have taken some time out for the lectures. So really thankful to you. And if any query is there, we will contact you regarding the same thing. Okay.
Yes. Yes.
Thank you once again.
Thank you. Thank you very much.
Students. So the students.